like your necklace, Gail, by the way.
Thank you very much.
It.
Thank you, Stephanie Gottlieb.
Boy, I don't know about you all, but certainly the last few months have kept me quite busy with all these crypto companies filing for bankruptcy and working with a bunch of our clients as buyers or potential buyers for these assets. And I just expect us to be busy in that space for this coming year.
What I find most interesting about these crypto cases is you have so many bankruptcy issues of law that have been settled for so many years, 10, 15, 20 years. And now you've got a whole new sector that the bankruptcy courts have never dealt with before. So we're handling a whole array of new questions that we're working on right now, like what is crypto and how is it going to be treated in bankruptcy? What is a depositor and what is its role in a bankruptcy? Is it a creditor, a customer,
Right.
An investor? And many people are trying to figure out, where did my crypto go and how do I get it back?
Yeah, and I mean, I think we're all looking to some extent for answers to come out of the bankruptcy courts, one of which just recently ruled, or at least as it relates to EARN program, the judge in New York. But, I expect that we'll see probably more decisions along those lines come out of the courts.
Yeah, it's really funny that we're here because I felt like when we opened 2022, the big question in the crypto space was whether crypto was a security. And now I think one of the big questions our clients are going to face in these bankruptcies is, if I withdrew my crypto within 90 days of the bankruptcy filing, do I have to give it back, and how do I value it? And what do we do next? And so I think we're going to be able to help our clients through those issues.
Yeah, some of the issues that are coming up, Doug, that you mentioned, right, are reminiscent of analogous issues we actually ran into in the Lehman bankruptcy with respect to the interpretation of prime brokerage agreements. Clients who had deposited securities with Lehman Brothers under these agreements, were the securities theirs? Were they segregated? Did they belong to the Lehman estate, et cetera? Those are all very similar questions to what is coming up now. And it's also, Gail, reminiscent of kind of what we saw coming out of Madoff with, clawback litigation that's gone on for years and years and years and is even continuing to this day.
Right. People are saying that they wonder if Sam Bankman-Fried has some hallmarks of Bernie Madoff, and I think the trustee is going to be very busy for a long time.
I would definitely agree with that. But, while crypto's sort of grabbed the headlines in the restructuring world for the last 4 to 5 months, I don't think we can lose sight of a lot of other interesting things that have been going on, including, multinational companies trying to use bankruptcy as a means to deal with mass tort liability associated with some of their operating divisions or subsidiaries. So, for instance, we saw J&J this year try and use a very aggressive approach under Texas law called the Texas two-step to effectively hive off all of their talc-related liabilities and try and insulate the value of the parent company and the rest of the business for the benefit of shareholders and other creditors.
Not quite as aggressively. 3M, another big multinational, they have a subsidiary called Arrow that's been involved in tons of litigation over the years for tort liability. 3M, trying to hive itself off from that liability, put the subsidiary into bankruptcy, trying to protect itself. And that's also gotten tied up in litigation as well.
Yeah, I mean, the companies, whether in the pharma space or otherwise, using the bankruptcy process to address their mass tort liabilities. We've been seeing that trend, really since 2020. And it's continued well into last year with Endo filing for bankruptcy to address its opioid-related liabilities. And then we saw certainly Mallinckrodt's plan filing go effective, and there's some litigation now stemming from that, unrelated to opioid issues that some of our clients are facing. But one issue that's come up in some of these mass tort-related sort of bankruptcies and it's grabbed the headlines is the issue of third-party releases.
Right.
That sort of rightened and took center stage in the Purdue pharma bankruptcy, and we'll see how courts are, higher courts are going to react on that issue. But that's certainly grabbed the headlines, been a central issue, for us all, right, as restructuring professionals at least.
Yeah, you mentioned litigation stemming from Mallinckrodt's bankruptcy. Even though the plan was effective, what the special litigation trustee says is that because of the mass tort liability, Mallinckrodt was actually insolvent as far back as 2015 when it started its tender offer program to buy back its own shares. So a lot of our clients received subpoenas this year seeking to understand whether they sold shares on the open market that Mallinckrodt might have bought back. And now there's litigation where our clients are being asked to actually pay back or buy back the shares that they sold to the company.
Right, and just by listening to you talk about it, it sounds kind of crazy, right?
Sure
Because
does.
we all know that the bankruptcy code has special provisions in it that are designed to protect the integrity of the financial markets, including the securities markets, and to insulate purchasers, buyers, and sellers in open market transactions from litigation of this sort. You can understand why it would be very unsettling for some of our clients to have to call you
Right.
saying, hey, I just got a knock on my door 7 years after I sold these securities and somebody's trying to get my money back. And it just seems unworldly.
It
And I'm
really
sure
is.
Gail's
Yeah.
going to be using those very provisions that you're talking about, Adam.
546E.
Right. Trying to defend our
Right.
clients.
It's a lot of fun explaining 546E and whether or not you're a financial participant in the market to our clients, but it really is a line of defense that we're going to be able to use to get our clients out of these seemingly crazy lawsuits.
So, a totally different topic, but another one that we've spent a lot of time on this year, up-tiering, where a borrower will work with a preferred lender or a group of lenders, and that lender will go up to the top of the capital structure and leave other folks behind, complaining and probably litigating. There's been a ton of litigation that stemmed from that. There's also been a lot of fighting over drop-down transactions where they take certain assets out of a secure loan and move it into another territory.
Yeah, interestingly, those litigations have kind of exited the bankruptcy space, and we're seeing them brought in Delaware, state court in New York, the Southern District of New York. We've seen it in Primark and Serta and board writers. And what's most interesting to me as a litigator is while they've been breach of contract actions, courts are now mixed, and some are letting this implied covenant of good faith and fair dealing claim go forward, which I've always called the claim of last resort, because they're now litigating whether or not the spirit of the contract has been violated, which you would think wouldn't actually be a viable claim, but we're finding that it is in some places.
Yeah, the decisions where the courts on the one hand find that the terms of the contract are clear and unambiguous and maybe even permit the transaction that's been challenged, but at the same time saying, well, maybe there's a claim here for a breach of covenant of good faith and
Right.
fair dealing would seem
Right.
to run in the face of what everybody thinks is well-established precedent, that if your contract is clear and unambiguous on its face, you don't go outside the four corners of the contract to try and determine the intent of the drafters.
Right, although I think it's because if you believe you're a secured lender, somebody shouldn't be able to prime you.
Right.
Unless your contract says they can.
Exactly, right.
Or says you can't.
Right.
Well, the courts have been sort of all over the map. They've come down on, there's no rhyme or reason, but it does seem like the trend in the last few rulings over the last year or so has been toward that more Gestalt-y approach, and maybe that's where the courts are headed, despite, Adam, the fact that it seems contrary to the plain language of the agreement.
Right.
So I think it's safe to assume that we're all going to continue to be very busy this year with everything that's that we've been dealing with this past year. Some of the issues that we're dealing with in the crypto space, the issues in the mass tort space, liability management, up-tiering type transactions, and then what's generally going on in the economy.
Yeah, look, I mean, I think we shouldn't lose sight of the fact that a lot of what's going on is also causing traditional financial institutions to back away from the capital markets and financing big, sponsor LBOs and other type transactions like that, which is leaving a very big void in the capital markets that a lot of our clients are actually filling. They have cash on their balance sheet. They have access to money to be able to make these kinds of loans. And so the direct lending market is actually stepping in where the traditional financial institutions used to play, which is going to be a big change in the overall lending market for years to come.
Yeah, now let's talk.